since we're I gotta do the continue here. Let's call the case of Marks versus Sonny's Rooftop Bar. My name is Judge Robert Aronoff. I generally am from the Los Angeles Superior Court. Scoring judges, please look into the two buttons in the lower left of your screen and turn off your audio and video. These should remain off until the trial ends. You should also have your video set to hide all non-video participants. This means that the only people on the screen right now should be the advocates and me. And are we set? I should probably put my non-video setting here. Okay, so that seems to be correct. Okay, can the attorneys please make their appearances?
Yes, Your Honor. Good afternoon. My name is Mehta, and along with my co-counsel, Adi Ramprakash, I'll be representing the plaintiff in today's case, Ethel Marks.
Okay.
Good afternoon, Your Honor. My name is Nia Boyd, and I'll be representing the defendant in today's case, Sonny's Rooftop Bar. I'm accompanied by my co-counsel, who is Sebastiana Emil, who will largely be off screen for most of the time, but she'll be accompanying me in the technical processes.
Good afternoon, Your Honor.
Good afternoon. Okay. Before we will now hear opening statements from each party. Everyone should make sure they are in speaker view. That button is on your in the upper right of your screen. Attorneys, please remember to mute your audio when the other attorney is speaking. Okay.
Your Honor, before we proceed with opening statements, is it all right if plaintiff has a few pretrial matters before we begin?
Certainly.
So just briefly, we'd like to invoke Rule 605, constructively swearing in all the witnesses.
That'll be done.
We'd also like to invoke Rule 615, sequestering all witnesses except the defendant, Sonny Mehta.
The record will reflect that as well.
And we'd also like to point out Stipulation 11, which states that Exhibits 1, 22, and 23 have been pre-admitted.
That's a stipulation?
Yes, Your Honor, stipulation.
Okay. They will be admitted.
And finally, in regards to screen sharing, would you like us to ask for permission before we screen share anything, or can we assume that all screen shared exhibits are constructively outside the view of the jury until the foundation is laid?
You can screen share at any point that you want, but be sure to lay your foundation when appropriate.
Yes, Your Honor. With that, plaintiff is ready to proceed.
Anything from the defense?
Your Honor, we would just ask that you tell us whether you would like us to object and state the basis.
Oh, of course, all objections should be state the basis of the objection, but not the argument. So if you object, for example, that's hearsay, you just say objection hearsay. Don't tell me why until I ask for argument on that.
Yes, Your Honor. And we would like to share our visual demonstratives that will be introduced into the court or in today's trial with opposing counsel, just to see if they have any problems with the makeup of it. They can object later if they would like to.
Okay, so they haven't seen it yet.
No, Your Honor.
Okay, why don't you show that now? So that
Ms. Emil.
Your Honor, I believe that all demonstratives were pre-approved by the people who are hosting this competition, and they were cleared of any issues, but we're still free to object to the demonstratives during the trial if we see that there are any issues with the demonstratives during the trial, but opposing counsel is still free to show me the demonstratives
Well,
before if she wants.
I think it's appropriate at this point for at least the other side to see the exhibits so they can be prepared, or if they have an overall total basis of objection. Let's show those demonstrative exhibits.
Yes, Your Honor.
Ms. Emile, if you could kindly share the demonstratives that we'll be using in today's trial. This is the full demonstrative for the opening. You don't have to show the exhibits, just the demonstratives. This is another demonstrative that'll be edited with outlines, if you will.
But what about, I just really saw pictures. I realized that I guess you were going to highlight those with outlines. The
I just wanted to make sure that they were okay with everything that was happening on the screen.
Okay. And the pictures are either stipulated to be admitted or there's not going to be a problem.
No, they're not stipulated to be admitted yet, so they can object during trial. I just want to make sure that everything on screen is okay by Ms. Mehta.
Okay. Any problem at this point, Ms.
No,
Mehta?
Your Honor. No issues at this point. However, if we feel that objections are necessary during the trial, we'll raise those at those time. But as of now, everything looks all right.
Okay. And do you have an exhibit or something you want to share in advance?
Yes, we can screen share after co-counsel is done, screen share our demonstratives as well.
Ms. Emile, you can continue.
Oh.
And the final one. And this one is basically the same thing from the initial Sony's observations demo. It's just in the closing argument. So that would be it.
Okay.
You can stop screen sharing, Ms. Emile. That's it for the defense's demos.
Okay, Ms. Mehta?
Yes, Your Honor. At this time, I'll ask my co-counsel to display our demonstratives for the trial.
That was it?
Your Honor, she's going to bring up the rest. Just a moment. That's all, Your Honor.
Okay. Any problems there?
No, Your Honor. With that, the defense is ready to proceed.
Okay. So let's begin with plaintiff's opening statement,
Yes, Your Honor. May I proceed?
please.
May it please the court, Ms. Boyd, members of the jury. They saw the signs. They kept serving. They didn't stop. It's March 24th, 2019, a slow night at a bar in Malibu. A 19-year-old girl walks in. She's on spring break. She's with her best friend, and it's their last night together. The bartenders take her orders, serve her drinks. They bring drink after drink after drink to her table.
I can't even use my hand to type anymore.
At the end of the night, she gets up, she pays her bill. She backs out of the parking lot
I'm done. I'm not trying to do anything else on this house ever again.
Your Honor, is it all right if I restart?
Yeah, well, what was that happening here?
I'm not sure. I believe someone accidentally unmuted.
Okay. Yeah, just back up a little bit. I got, you know, you don't have to start at the beginning.
Yes, Your Honor. Just wanted to make sure everyone could hear.
No, it was a little distracting. The first one I got through, and then the second one I was going, you know, what was that? All right.
The bartenders, they take her orders, serve her drinks, bring drink after drink after drink to her table. At the end of the night, she gets up, she pays her bill, backs out of the parking lot. Just minutes after she turns onto the road, she loses control. She swerves. She dies. Her name was Jessica Marks. She was a student, a friend, a daughter. But to the employees of Sunny's Rooftop Bar on the night of March 24th, 2019, she was just another transaction. They saw the signs. They kept serving. They didn't stop. That's why today, as the plaintiff, we've brought a claim for wrongful death against Sunny's Rooftop Bar, the defendant in this case for causing Ms. Marks' death. And today, as the plaintiff, we have the burden of proof. It's our responsibility to prove to you by a preponderance of the evidence that Sunny's Rooftop Bar served Ms. Marks when she was obviously intoxicated and subsequently caused her death. And we'll do that today by focusing on two things: what they saw and what they served. Today, you'll learn that the employees at Sunny's Rooftop Bar, they saw the signs in Miss Marks that night. Miss Levin will get to the stand today and tell you how Miss Marks's behavior changed as the night progressed that night. You'll learn how she was slurring her words, how her eyes were red, how she could hardly stand on her feet. But that the employees at Sunny's Rooftop Bar continued to serve her. You'll learn what they served. The defendant, Sunny Mehta, will come to the stand today and tell you that for 2.5 hours, he took Miss Marks' orders, served Miss Marks' drinks, and that he brought drink after drink to her table and didn't cut her off. Members of the jury, they saw the signs, they kept serving, they didn't stop. And at the end of this trial, we'll ask that you find Sunny's Rooftop Bar liable. Thank you.
Okay, the defense.
Ooh. Yes, Your Honor. Ooh. Must be muted. Okay. May it please the court. The choices we make are the consequences we face. Jessica Marks tragically died on March 24th, 2019. The death of this 19-year-old was terrible. But the defendant, Sunny's Rooftop Bar, is not at fault. Members of the jury, my name is Nia Boyd, and I represent Sunny's Rooftop Bar in today's case. Today, the defense has no burden, but the plaintiff does. And they have to prove to you by a preponderance of the evidence, which is more likely than not, that Jessica Marks was showing obvious signs of intoxication to the defendant that night. But we're going to show you the flaws in their theory. Specifically, we're going to show you with 3 questions that I want you to keep in mind. 1, what were Morgan's choices? 2, were the choices that Sonny's Rooftop Bar made reasonable? 3, what choices did Jessica Marks make? Now, in today's trial, you're going to hear about Morgan Levin's choices. You're going to hear how Morgan Levin, he chose to go to that bar and use a fake ID. And in testimony, you're going to hear the holes in Morgan Levin's memory. You're going to see that they can't remember much of that night. Specifically, they won't be able to tell you when Jessica started exhibiting signs of obvious intoxication. Now, opposing counsel, Ms. Mehta, got up here and told you that Jessica Marks was just another transaction for Sonny's Rooftop Bar. But that's not true. The truth is that Sonny saw no signs of obvious intoxication. And in today's trial, you're going to hear how Sonny was trained to identify those signs. She didn't see Jessica slurring, stumbling, or with a flushed face. She never saw any of that. And you'll hear that today. But the most important thing that you'll hear, members of the jury, is what Jessica chose to do. You'll find that after spending the night at Sonny's Rooftop Bar, Jessica chose to drink and drive. You'll also hear that she was offered an Uber. Members of the jury, at the end of today's trial, I'll come before you again and ask you to make a choice. And your choice will need to be reasonable and responsible, because the choices we make are the consequences we face. Please find Sonny's Rooftop Bar not liable. Thank you.
Thank you, counsel. Before we call our first witness, I will ask everyone to switch to gallery view. That button is in your upper right of your screen. This will allow you to see the attorneys and witnesses at the same time. So with that, will the plaintiff call our first witness?
Yes, Your Honor. At this time, plaintiff calls Morgan Levin to the stand. May I proceed?
Please.
Good afternoon, Mr. Levin. Before I begin, I just want to make sure, can you see and hear me okay?
Yes, I can.
Please introduce yourself to the court.
Hello, my name is Morgan Levin.
Do you know why you're here today, Mr. Levin?
I do. Yes, I was with my friend Jessica Marks, the night she died.
Now, before we get into that night, Mr. Levin, I want to talk to you a little bit about your friend Jessica. Your Honor, at this time, we'd like to display what's been marked as Exhibit 2 on the screen, constructively outside the view of the jury.
Okay, I think we had just said you can display the items without.
Do you recognize the woman in this picture, Mr. Levin?
Yeah, that's Jess. I think this picture was back in high school.
Did you take this picture?
I believe so.
Your Honor, at this time, we offer Exhibit 2 in evidence.
Any objection?
No, Your Honor.
It'll be so admitted.
Mr. Levin, could you tell us a little bit about how you knew Miss Marks?
Sure. Jess was my best friend. I met her back in junior high. We connected at first because we had the same birthday. And then after that, we became best friends through high school. We even stayed in touch during college.
Now, Mr. Levin, I want to talk to you about March 24th, 2019. I understand this may be difficult for you, so we'll keep this quick.
All right.
Mr. Levin, where were you and Jessica that night?
We had decided to go to Sunny's rooftop bar. It was down in Malibu.
What time did you get to the bar that night?
We probably walked in around 9 p.m.
How busy was the bar that night?
It was somewhat busy. I remember a couple other people there.
And you got to the bar. What did you do next?
Well, when we got inside, we went up to the patio up on the roof, and we ordered our first drinks.
Who paid for the drinks that night?
I did. I covered the bill for both of us.
Would you recognize a receipt if I showed you one?
I should be able to, yes.
At this time, we'll be displaying what's been marked as Exhibit 17 on the screen. Do you recognize this?
Yes, this is my receipt from that night. That's my signature down at the bottom.
Is it a fair and accurate depiction of your receipt?
Yes, it is.
Your Honor, at this time, we'd offer Exhibit 17 into evidence.
Any objection?
Yes, Your Honor, under 801 hearsay.
Response, Your Honor.
Please.
Your Honor, this receipt was printed by the party opponent in this case, Sunny's Rooftop Bar.
In response to that?
No, Your Honor.
No, it'll be deemed admitted. Continue.
Mr. Levin, did you pay for Miss Marks's drinks as well?
Yes, I did.
I want to talk about the drinks you had that night. What drinks did you have?
Well, I had 3 drinks total. I had 1 glass of the decoy red blend, that's wine. I had 1 IPA, that's beer, and 1 green tea shot.
What about Miss Marks? What did she order?
She had the rest of the drinks, so the rest of the bottle of wine, maybe 2, even 3 glasses of it. She had 3 White Claws, an IPA, and the other green tea shot.
Now, Mr. Levin, how long were you and Miss Marks at the bar that night?
Almost 3 hours. We got there at 9 p.m. and left close to midnight, so around 3 hours.
For the 3 hours that you were at the bar, who took your orders?
It was mostly Sunny. She introduced herself that night. She was on the patio most of the time from what I could see.
Who served all those drinks to you and Miss Marks?
That was Sunny.
Now, I want to talk about Miss Marks's behavior that night. Now, you mentioned that Sunny took your orders and served your drinks. About how many times would you say he interacted with you and Miss Marks?
Well, between taking her order, delivering the drinks, I'd say 8, 9, maybe even 10 times.
And in those time that you were at the bar, could you describe how Miss Marks's behavior changed as the night progressed?
Yeah, as the night went on and we were ordering more drinks, Jess's behavior just became worse. It seemed like she was getting more drunk as the night went on. I remember one time she even stumbled down the stairs.
And did the bartenders cut her off after that?
No, they never did.
Did you take any videos of Miss Marks that night?
Yes, I did one at around 11 at that bar.
Your Honor, at this time, we'd like to display what's been marked as Exhibit 10 on the screen. Do you recognize this, Mr. Levin?
Yes, this looks like the frame, the first frame from a video I took of Jess at around 11 that night.
Your Honor, at this time, we'd offer Exhibit 10 into evidence.
Any objection?
No, Your Honor.
It'll be admitted.
We'd like to play this video for the jury now, co-counsel.
Okay.
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. You know, I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Thank you, co-counsel. Mr. Levin, when was this video taken that night?
I recorded it around 11 p.m. at the bar.
Did the defendant continue to serve Miss Marks?
Yes, right after that, I believe that's when we ordered a round of shots.
What time did you and Miss Marks leave the bar?
11:45.
Thank you, Your Honor. No further questions at this time.
Cross-examination.
Yes, Your Honor. If I could have permission to move about my well briefly.
Sure. We've lost you.
Sorry about that, Your Honor. Good afternoon.
Hello?
I want to direct your attention to Exhibit 4 in your virtual pamphlet. Do you recognize this exhibit?
Yes, this is a fake ID that Jess made for me.
At this time, the defense would like to enter Exhibit 4 into evidence.
The objection.
Yes, Your Honor. We'd like to object to a hearsay.
Explain it to me, please.
Yes, Your Honor. We see on this exhibit that there are out of court statements which haven't been yet entered into evidence, and we believe that opposing counsel is offering these for the truth of the matter asserted. Therefore, they are hearsay.
Well, for example, it shows that he's an organ donor, but is that a problem in this case? And I assume if you ask him, well, I don't know, maybe he needs to be asked if he's an organ donor, but is that the type of thing you're thinking is wrong or hearsay? He did say it was a fake ID, so therefore I don't give much credibility to anything on there. As far as fact, I don't know. You know, I didn't hear that he's from Philadelphia or again, organ donor. There's, it's a fake ID, so it shouldn't be trusted as anything other than fake ID. That's what I see it as. Any further argument?
No, Your Honor, not at this time.
Okay, it'll be deemed admitted.
Mr. Levin, you're aware that you used this ID on the night of March 24th, 2019?
Yeah, I was only 19. That's how we got into the bar.
Objection, Your Honor, as to character evidence. May I make an offer of proof, Your Honor?
Sure.
Your Honor.
I'm not sure I understand the objection, but go ahead.
Your Honor, during opening statements, opposing counsel mentioned that they were going to, a part of their case was to discuss the choices of Mr. Levin. And we believe that they are offering this into evidence and discussing the fact that he used a fake ID that night for propensity purposes and to establish that he acted in accordance with a certain character on that night.
May I respond, Your Honor?
Sure.
We're asking about the witness's credibility and seeing that using a fake ID is a crime of truthfulness. It's fully admissible under Rule 809.
It'll be deemed admitted.
I'll repeat my question, Mr.
Yeah.
Levin.
Please. Repeat.
Oh. I'm sorry. I'll repeat my question, Mr. Levin. You used this ID on March 24, 2019, right?
I did, yes.
And you're aware that using a fake ID is illegal, correct?
Yeah, I was underage.
Now, earlier you stated that Jessica gave this to you, didn't you?
Yeah, we decided that we would just use fake IDs to get into the bar.
I want to talk about March 24th when you entered that bar. You went to Sony's, right?
Yeah, Sunny's rooftop bar down in Malibu.
And you were with Jessica most of the time, if not all.
Yeah, pretty much the whole time I was with her.
You would say that you were with Jessica longer than Sony, wouldn't you?
I mean, yes, we went together, so we were together most of the night.
Okay. Let the record reflect that my co-counsel is now screen sharing what has been pre-marked as Exhibit 8 and 9. Do you recognize these photos, Mr. Levin?
Yes, these look like pictures of Sunny's bar, although the one on the right was taken during the daytime. We were there at night.
Okay. At this time, defense would like to enter Exhibits 8 and 9 into evidence.
Any objection? Hearing none, it'll be admitted. Proceed.
Oh, Mr. Levin, Sonny's had an upstairs, right?
Right, that's the picture on the right. That's where we were most of the night, the patio.
And Sonny's had a downstairs, right?
Yes, that's the picture on the left.
And you're aware that the bar was downstairs, aren't you?
Yes, the bar was downstairs. There were also a few bathrooms too.
But there were no bars upstairs, were there?
No, just a seating area.
So in order to get to you, a server would need to go down the stairs, right?
Well, we would be upstairs, so they would come up to us.
Okay, so they need to go up the stairs to get to you, right?
That's right, yes.
And then back down once they were finished serving.
Yes.
Now I want to talk about the drinks that you ordered. You ordered around 8 drinks that night, right?
Yes, between the both of us, it was around 8.
But you can't remember what order you ordered them in.
Well, I know we ordered the wine first, but other than that, I don't know the right order.
Okay. Throughout the night, you proceeded to say that Jessica was getting drunker and drunker, didn't you?
It seemed to me Jessica's behavior wasn't the Jess I knew. It was someone else.
But you say that this wasn't the Jess that you knew, but you don't remember around what time she started displaying these symptoms that you observed?
The specific time, no. I know she got more drunk as the night went on, but I don't know the right time.
But Mr. Levin, you do remember that she entered tipsy, don't you?
Right. When we got there and first arrived, she appeared a little buzzed, maybe tipsy. Right.
So when she first entered the bar, yes or no, she appeared tipsy to everyone else.
Well, I don't.
Objection as to lack of personal knowledge on the part of the witness.
Well, You can cross-examine it, but he's saying what he observed and he did enter the bar with it. Where do you see lack of personal knowledge?
Your Honor, I believe opposing counsel's specific question was, did Miss Marks appear tipsy to everyone else? And that is not something that that my witness can testify to. He can testify to what he saw that night, but not to what everyone else was able to see.
Okay.
May I respond, Your Honor?
Sure.
Since this is cross-examination, if the witness doesn't know a piece of information, they're allowed to say so with a yes or no.
Well, I think the objection should have been phrased as speculation, and on that basis, I'll sustain it. We don't know what the other people observed because we don't have them as witnesses. He can testify to how, if she appeared tipsy to him, then he will say that. But there's other ways to maybe expand upon her appearance and how it might have appeared to other people. But the objection based upon speculation will be sustained. Please rephrase your question.
Yes, Your Honor. You stated that Jessica seemed tipsy upon entering the bar. Yes?
Right, when we first got there.
Okay. I want to talk about when you left, though. You said that Jessica performed a sobriety test on herself.
In a way, yes. Outside in the parking lot, she showed me if she could walk in a straight line.
And you believe she looked fine.
I wouldn't say fine, no. She looked maybe less drunk than I thought, but definitely not fine.
Okay. But you did offer Jessica an Uber that night?
I asked her, I begged her to get in that Uber with me, but she didn't want to.
No further questions at this time, Your Honor.
Okay. We have redirect examination.
Yes, Your Honor, briefly. Mr. Levin, opposing counsel asked some questions on cross-examination about the stairs and where the bar was located at Sunny's Rooftop Bar. Where did you see the defendant spend most of her time at the bar that night?
Well, it seemed to me that Sunny was on the patio most of the time. I think she might have even been the only server there. So most of the time she was on the roof when I saw her.
No further questions, Your Honor.
Okay, I guess there's an opportunity for a recross. Okay, so that satisfies this witness, can be excused.
Are you offering a recross for the defense, Your Honor?
I am. I thought I saw you shake your head like, no, you didn't have one.
Oh, okay. No, Your Honor.
You have no.
No recross, Your Honor.
No recross. So then that concludes this witness can be excused. Okay, and then we, now I'm a little off on the procedure here. Does the defense call their witness now?
Yes, Your Honor. Plaintiff rests at this time.
Okay.
Your Honor, the defense would like to call Sunny Mehta to the stand.
Okay. You may proceed.
Good afternoon.
Good afternoon.
Would you please introduce yourself to the jury?
Yeah, of course. Hello, my name is Sunny Mehta.
And where do you work, Ms. Mehta?
Well, back in 2020, I sold the bar that I own, Sunny's Rooftop Bar. So now I'm looking to proceed with a new business venture.
Ms. Mehta, why are you here today?
Well, you know, as much as it breaks my heart to say this, there was a mishap that happened after leaving my bar. A customer crashed their car and passed away, Jessica Marks.
I want to talk to you about that bar you previously owned, Sunny's Rooftop Bar.
Yes.
What did it take to own that bar?
It took a lot. You want to make sure that your customers are going to be safe. So there's a lot of different safety courses that you got to go through, a lot of different certifications that you have to get through in order to own your own bar. And then once you're there, you go through pretty regular training.
What you mentioned some certifications. What did these certifications entail knowing?
It's mainly about figuring out how customers act intoxicated so that you know their limits and that you know when to cut them off. That's extremely important when you're owning a bar. You want to make sure that no customer is leaving if they've had too much to drink.
Now, you mentioned cutting someone off. Were there any other precautions that you would take while owning this bar?
Yes, of course. There were times where I took away customers' keys. They didn't like it at the time, but it was just the necessary safety precaution to take. And there were other times too where I would either step in and call them a cab or I would call them an Uber, just anything to make sure that that customer got to their next location, whether it was home or another place of their friends, as safe as possible.
Ms. Mehta, I want to talk to you about obvious intoxication. What does that mean?
In all of our training, in order to be a bartender and to own my own bar, we learned that obvious intoxication is when a reasonable person could assume that a person is drunk. If that person is displaying signs or symptoms of intoxication and it reaches a certain point, then it would fall into this category.
Let the record reflect that my co-counsel is now screen sharing a visual demonstrative for the aid of the jury. Ms. Mehta, what are some signs of obvious intoxication?
One of the signs that we really look for is slurred speech. Another one are the customers being obnoxiously loud. We also look and see if the customer is poor coordination. Are they stumbling? Are they tripping into things? And also we look at their faces. We want to see if they have a flushed face. That's usually a good indicator that they are either tipsy or they're buzzed or they're starting to be overly intoxicated.
Okay. Ms. Mehta, let the record reflect that my co-counsel is now sharing what has been already admitted into evidence as Exhibit 2. Ms. Emile. Do you recognize this girl?
Yes, that is Jessica Marks.
Where do you recognize her from?
She was at my bar on March 24th.
When she came into your bar, did she ever order anything?
Yeah, she did. She ordered some drinks and some chips as well.
Around what time did you start serving Miss Marks?
When she came to the bar a little bit after 9.
And how long between these interactions would you interact with Miss Marks?
I definitely interacted with her a few times, getting the orders, bringing the food, bringing the drinks. So several times throughout the night.
And when you interacted, was this a long amount of time or?
No, not really. I had to serve other customers that night. And as much as I love connecting with my customers and having those kind of conversations, I have to make sure that I get them their drinks and then I go and make sure the other customers are also taken care of.
Ms. Mehta, I want to discuss with you the behavior that you saw that night. If my co-counsel would now share, thank you. Did you ever see Jessica slur her words?
No, not that I can remember, no.
Was Jessica ever loud?
So Jessica was loud. However, the thing that I remember too is that there's always some louder music. So everyone has to raise their voice if they want anyone to hear them.
Did she ever have poor muscular coordination?
I never saw her doing any of that.
Was she ever stumbling that night?
I also don't remember seeing Jessica ever falling or stumbling.
Did she have a flushed face? I want to talk about Morgan Levin's behavior. What did you observe that night?
Morgan was a little bit of a different story. Morgan, was starting to get a little bit more buzzed as the night went on, and that started to worry me. So later on in the evening, I talked to Jessica and I was saying that I hoped Morgan wasn't driving. And it made me really glad when I learned that Morgan wasn't.
Okay. Were you in court today when you saw the video that was played earlier?
Yes, I was.
No. Did you ever see this video being taken in your bar?
No, I was not present for that video, or if I was, I never saw it actually being filmed.
Okay. I want to talk about when they left. Did you ever have any concerns for Jessica?
No, so I was actually watching as they were leaving the bar, leaving the roof, because there's that roof setup that you saw earlier. They were walking down and I was watching Jessica walk down the stairs and she looked fine. So I did not have any concerns for Jessica at that point.
Did you ever have any concerns for Morgan Levin?
Yes, so she actually did show some signs of trouble. She was coming down the stairs just a little bit more wobbly. And then towards the end of the night, when she was signing the check, she seemed to have some issues writing her name, writing down some of the numbers. So I was a little bit more concerned about Morgan, yes.
Thank you. No further questions at this time. Oh, actually, I do have one more question. I want to talk to you about what you meant by she had done her numbers wrong. What did you mean?
Right. Well, we saw Morgan. She was walking, trying to get the receipt, everything taken care of, pay for the drinks. Because while her and Jessica were both ordering, it was Morgan who was paying for the drinks. And if you look at this check, you can see that something's a little bit off. It says the gratuity is $20, but then if you look at the math, it should actually be $139, but then the math is a little bit off. So she was having some trouble actually doing the math correctly on this check.
No further questions at this time, Your Honor.
And cross-examination.
Yes, Your Honor. May I proceed?
Yes.
Good afternoon, Ms. Mehta.
Good afternoon.
I'm going to ask you some questions today about your testimony and what you've said previously. I want to first start off talking about the video that you saw earlier in today's trial. Ms. Co-Counsel, could we get a picture of that video up for the jury, please? This is a screenshot of that video that we saw earlier in today's trial, isn't it?
It is.
And Ms. Mehta, this was taken on your rooftop that night, right?
That's what this looks like, yeah.
You recognize this as one of the tables on your rooftop?
Yes.
And like you said on direct examination, you were the one serving drinks to people that night on the rooftop, right?
Yes, maybe not all of them. Frankfurt Johnson was also working that night, but I was doing the majority of the serving.
But just to be clear, Ms. Mehta, you spent most of your time that night on this rooftop.
That is true, yeah.
I want to talk about the drinks that you served Ms. Marks. You were the one who took her orders that night.
I did.
You served her drinks.
I did, yes.
Your Honor, at this time, we'd like to display what's been marked as or pre-admitted as Exhibit 17 on the screen.
Go ahead.
Now I want to talk about the Exhibit 17, sorry.
Are we displaying 17?
Yes, Your Honor. I believe my co-counsel is having some technical difficulties. We'll move on, Your Honor. Looks like we got it. Ms. Mehta, this is the receipt from that night of Ms. Marks, right?
Yes.
You served all these drinks to Ms. Marks's table.
Yes, to her and Morgan Levin.
I want to walk through all the drinks that you served Miss Marks and Morgan Levin that night. You served them a bottle of wine, right?
I did.
And can we get the chart up for the jury co-counsel? And that's 14% alcohol, right?
Yes.
You served them you served White Claws to the table, right?
I did.
And that's 8% alcohol.
Yes.
You brought two types of beer. You brought a Ballast Point, which is 7%,
Yes.
and a Sierra Nevada IPA can, 6.5%.
Yes.
And then you also served shots to the table that night, right?
I did. Yes.
You served 2 green tea shots,
I did.
15% and 40% alcohol.
Yes.
And Miss Mehta, Miss Marks was 5 feet tall, wasn't she?
If I'm remembering correctly, yes.
You served all these drinks to Miss Marks's table, right?
To her table with Miss Levin, yeah, I did.
And she was about 110 pounds, you'd say?
I mean, I didn't have a scale to weigh her, but that's what, if I was going to eyeball it, that would be my best guess.
Miss Mehta, you served all of those drinks to Miss Marks's table that night, and it's your testimony that she was perfectly sober when she walked out.
That is not. You have to understand, obviously intoxicated doesn't mean just that they're intoxicated. A person can be intoxicated, but not actually show signs. What I'm saying is that there were no signs that day that led me to believe that she was obviously intoxicated. Nothing that my training would stop them at.
Thank you, Miss Mehta. Redirecting you back to my question, it's your testimony that Miss Marks, to you, looked perfectly sober after drinking all those drinking drinks and walking out of your bar, right?
Yes, she displayed no signs of obvious intoxication.
I want to talk more about the drinks you served that night. You mentioned that you weren't around when the video was taken.
I was not, no.
Sorry. But like you said before, you spend most of your time on the rooftop that night, right?
Yes.
At this time, can we get pictures of Exhibit 15 and 16 on screen? You recognize these pictures as pictures of Miss Marks and Miss Levin's table that night at your bar.
Yes, I do.
These were taken on your rooftop.
Yes.
And you recognize that that is Miss Marks in that picture.
Yes. I mean, her head is cut off, but from the body, yes.
And you remember serving these drinks to her table that night?
I remember serving her drinks, but I can't recall the exact drinks that I served without looking at a receipt, as it was so long ago.
To you, it looks like a fair and accurate depiction of their table that night.
Again, it was such a long time ago, but from what I remember, yes.
Your Honor, at this time, I'd like to offer Exhibits 15 and 16 into evidence.
Any objection?
No, Your Honor.
They'll be so admitted.
Now, Miss Mehta, Exhibit 15, that was a picture that's stipulated to be taken at 10:57, right?
Yes, that's what I've heard.
In that video, it was stipulated to be taken around 11:11.
I've also heard about that, yes.
And
Objection under 602. She's asking about stipulations. The witness has no personal knowledge about stipulations, Your Honor.
Repeat the question, please.
Your Honor, I asked, Exhibit 16 was stipulated to be taken at 11:32 p.m.
Was that a stipulation or not from your stipulation? Counsel, you can either say that wasn't or was not.
It was stipulated, but the witness has no personal knowledge about stipulations, Your Honor. And so it would be a need for personal knowledge for her to agree that it was stipulated that this was the time taken of the exhibits. Furthermore, she wasn't there when the exhibits were taken, so the stipulation wouldn't actually be in her personal knowledge.
Well, I'm going to overrule the objection. That's a very minor point. Everyone, it's stipulated that picture was taken at 11:32, and you know, he doesn't have to re-verify that. And
Yes, Your Honor.
if you ask me, that picture was taken at 11:32 because you guys stipulated to it, and it says it. So I wasn't there. Go ahead, continue the cross-examination, please.
Now, Ms. Love, in talking about these pictures, these were all taken about 30 minutes within each other?
Yes, that's what the timestamps are saying.
So between pictures, Exhibit 15 and Exhibit 10, we see that the beer was refilled, right?
Yes, or it wasn't. Yes, do you see that?
And we see that between 10 and 16, the water carafe was refilled.
Yes.
So, Miss Marks, one of your employees, whether it was you or someone else, came to your table that night within 30 minutes of that video and refilled drinks.
Yes, I mean, as we were taking orders, it was a continuous kind of process. They give us an order and we bring back what they've ordered.
No further questions at this time, Your Honor.
Okay, redirect.
No, Your Honor.
Okay, so this witness can be excused.
Yes, Your Honor. The defense rests their case in chief.
Okay. We're ready for closing argument. Do we need to take a break or anything before? We may be running low on actual time anyways, but is there a point, is there supposed to be a break at this point? Or do we go right into closing argument?
Your Honor, plaintiff is ready to proceed with closing arguments.
Okay. Then everyone should please switch back to speaker view. Also, since both witnesses have completed their testimony, you can complete, those scores can complete that portion of your ballot. Okay, let's proceed with closing arguments. Plaintiff.
May it please the court, opposing counsel, members of the jury. They saw the signs, they kept serving, they didn't stop. Members of the jury, it's that simple. 9 drinks. Today you learned that the defendant, Sonny Mehta, Sonny's Rooftop Bar, served a 5-foot-tall, 110-pound teenager 9 drinks. Today, they told you that Miss Marks looked perfectly sober that night. Perfectly sober, walking out of the bar after being served all those drinks. And members of the jury, we proved to you that on March 24th, 2019, Sonny's Rooftop Bar served Miss Marks when she was obviously intoxicated and subsequently caused her death. That was our burden today. And we met that burden by focusing on 2 things: what they saw and what they served. First, before I proceed, I want to clarify what obviously intoxicated means. Defense got up today and told you a lot about training, Miss Sunny Mehta had gone through, training that her employees had gone through. But members of the jury, you don't need to be an expert to tell if someone's obviously intoxicated. You don't need a certification to look someone in the eye and see if they've had too much to drink. And members of the jury, today you learned that when Miss Sunny Mehta looked Miss Marks in the eye that night on March 24th, 2019 at Sunny's rooftop bar, instead of cutting her off, instead of telling her it was time to stop, they looked her in the eye and they poured her another glass. We proved that to you today by focusing on two things. Let's start with what they saw. You learned today that for 2.5 hours, Miss Mehta served Miss Marks's drinks, took Miss Marks's orders, brought 9 drinks to her table, cleared her table, took her orders. Members of the jury, Miss Mehta got up and told you today that Miss Marks looked perfectly fine. But you saw today on cross-examination a video of Miss Marks, a video of how she looked that night. And that in just within minutes of that video being taken, Miss Marks's drinks were refilled. They brought a beer to her table. They refilled her water carafe, yet they want you to believe that they just didn't see how Miss Marks was acting. It doesn't make sense. It doesn't make sense because it's not true. Miss Levin got up to the stand today and she told you that Miss Mehta came to their table 8 to 10 times. And that Miss Marks displayed signs of obvious intoxication in front of Miss Mehta. You learn that she stumbled on the stairs, that instead of cutting her off, Miss Mehta joked about it and proceeded to pour her more drinks. Members of the jury, the defense today tried to distract you from the matter at hand today. They talked about choices of Miss Levin, choices of Miss Marks, but members of the jury, there was no choice as deadly as the defendant's decision to pour Miss Marks another glass. They'll try to blame Miss Marks for what happened that night, a 19-year-old girl who was under the influence, and they'll ask you to consider her liability, but members of the jury, she was 19. She did everything she could to take care of herself, but she was incapacitated by the defendant's decision to pour her another glass. And that's why today we ask that you find Sunny's rooftop bar liable. Thank you.
Okay. Ms. Boyd?
Yes, Your Honor. Members of the jury, the choices we make are the consequences we face. Earlier, I asked you to keep in mind 3 important questions. What choices did Morgan Levin make? Were the choices that Sunny's rooftop bar made reasonable? And finally, what choices did Jessica Marks make? Earlier, you heard today that Morgan used a fake ID. And that was one of the choices that Morgan Levin decided to make that night. You also recall that Morgan Levin chose to drink that night. He chose to go into that bar with Jessica, with their fake IDs, and drink. Now, Ms. Mehta just got up here and told you that just got up here and told you that Morgan Levin observed signs of Jessica being obviously intoxicated. But members of the jury, I want to remind you of the standard in today's case. The standard is a reasonable person. And because of Morgan Levin's choices that night, he's not a reasonable person. He was under the influence of alcohol that night, which we heard on Miss Mehta's direct. You heard that Morgan Levin was wobbling and exhibiting signs. That's not a reasonable person. But something else you also heard from Morgan Levin on today's cross is that Jessica was already tipsy when she entered the bar. This was the first thing that Miss Mehta had saw of Jessica. She had never seen Jessica in her life. And our standard is a reasonable person, not a biased person. We already know that Morgan Levin, he knew Jessica for years. There was no way that Sony could have stayed on that rooftop long enough to see the behavior exhibited in the video. Which brings me to my second point. Was Sony's choices reasonable? You heard today that Sony never saw any signs of Jessica being obviously intoxicated, and that she had brief seconds of interaction. There was no possible way that she could have seen her long enough. And as Ms. Mehta pointed out earlier, she is trained. She's trained and certified to identify when someone is exhibiting obvious signs of intoxication. And that night, Jessica wasn't. We could get that demo back up on the screen, Miss Emile. She wasn't slurring. She wasn't stumbling. She wasn't loud. She was loud maybe, but the bar had music playing. I mean, she didn't have poor muscular coordination. She wasn't stumbling about. And she didn't have a flushed face. There were no signs that Sony could see Jessica Marks exhibiting that would give her the belief that she was obviously intoxicated. Now, the plaintiff case relies on a video that Sony was never there to see. In that video, you never saw Miss Mehta standing next to Jessica. You never saw her actually in the video. She wasn't even aware that it was taken at her bar. But members of the jury, we need to be aware. Specifically, we need to be aware of Jessica's choices. Ms. Mehta just got up here and told you that she was only 19. And that's right. She was only 19. Which is why it's tragic to talk about today's case. Earlier, I told you the choices we make are the consequences that we face. Let's review Jessica's choices. That night, Jessica chose to drink before going to the bar. She chose to enter the bar already tipsy. She chose to get behind that wheel and drive to the bar, continue drinking at the bar, drink in access at the bar. She chose not to take the safe route that was offered to her, as we heard on Mr. Morgan's cross when she was offered an Uber. She chose to get behind that wheel. And she made that fateful choice that we're constantly warned about. We see stories in the media. We hear it from our officers. We hear it from our parents, our mothers, our fathers. Don't drink and drive. Which is exactly why we need to make reasonable choices. A reasonable choice would have been to get in that Uber and pick up the car the next day. A reasonable choice would have been to not drink and drive. It's a tragedy that a young girl died. And we understand that it's hard, but members of the jury, the choices we make are the consequences we must face. There was no possible way that Sony Mehta could have seen something that was never there. Please find her not liable. Thank you.
Do we have any plaintiff's rebuttal in this procedure?
Yes, Your Honor. We have about a minute left for rebuttal.
Okay, please proceed.
Members of the jury, the defense wants you to focus on Miss Marks' decision to drink and drive. But at the same time, they want to tell you that Miss Marks didn't look intoxicated when she was at the bar. Members of the jury, they can't have it both ways. They can't tell you that Miss Marks drank and drove and that that was a bad decision, and tell you at the same time that she didn't look intoxicated to Miss Mehta at the bar. They have to pick one side. And today you learned that the only viable side is what you heard today. That Sonny's rooftop bar saw the signs, but they kept serving, and there is no other explanation for what happened. Find them liable. Thank you.
And normally we don't have a rebuttal on the closing, but I think there is in this proceeding. Is that correct? In this competition?
No, there's no rebuttal in this competition, Your Honor.
All right, so then we're done with the trial, correct?
Yes, Your Honor.
Okay, so the judges should please complete their ballots and click submit. I will ask everyone to stay on until everyone has submitted their ballots, and then we will do some brief comments.